When selling a portion of a larger property, a seller is free to place a burden on one property for the benefit of the other property. However, burdening a property for the benefit of a stranger property is historically a different matter. In Tripp versus Huff, we'll explore whether there was a compelling reason to go against precedent to allow an easement to benefit a party who wasn't a party to the land sale. Captain Ichabod Jordan conveyed a piece of land abutting a roadway to Nicholas Hearn. Later, in 1833, Captain Jordan conveyed a 40-acre parcel of land north of Nicholas's land to Jeremiah and Nicholas Hearn jointly. In 1863, the pair divided the 40-acre land in two. Nicholas was named the sole owner of the southernmost half of the property, which connected to Nicholas's parcel abutting the roadway. The landlocked northern half became Jeremiah's. Later that year, the portion of Nicholas's property initially conveyed to him by Captain Jordan, which separated the formerly jointly owned parcel from the roadway, was sold to William Andrews. The deed stated that Jeremiah and his assigns were to be provided a right-of-way over the property being conveyed to Andrews so that Jeremiah could still access his parcel. Andrews later sold his property to A. Kenneth Huff and Alfred and Joanne Barlow. Jeremiah sold the landlocked northern property to David Tripp. Tripp sued Huff and the Barlows in York County Superior Court. Tripp alleged that the language in the deed to Andrews provided Jeremiah and his assigns, meaning Tripp, an express right-of-way to access the roadway. The parties stipulated that Jeremiah was a stranger to the deed between Nicholas and Andrews. Tripp also argued that he had an easement of necessity and implication. The trial court determined that Tripp didn't have a right-of-way over Huff's and the Barlows' land. Tripp appealed to the Maine Supreme Judicial Court.